Hi and welcome to the Forbes Let's Talk Commercial Edition. I'm your host Sheroze Nadeem, and this podcast series will include guests from various different commercial teams. Hi Daniel, and welcome to the first edition of the Commercial Podcast. Thank you for joining us.
Hello Sheroze, it's good to be here. It's good to be on the inaugural Commercial Podcast. Lots to talk about, and I'm happy to be here.
Well, most definitely lots to talk about. We're going to discuss all things IP and also a bit about you. So before we get started, tell us about yourself, Daniel. What's the journey look like, and where is it you are now?
Yeah, sure. So for those that don't know, my name's Daniel. I'm a commercial associate at Forbes. I've been at Forbes now for nearly 6 years. Started life as a paralegal, trained in our insurance, corporate and commercial teams, and then qualified here nearly 4 years ago now. So since then I was tasked with the role of growing the intellectual property offering at Forbes, and that alongside commercial services is the area that I focus on. So it's been a very busy 6 years there or thereabouts, but also a good one as well.
No doubt you'll have seen changes from when you first started to the 6 years now, and the world of IP is so fast-paced and moving that every day is a new day, and there's new challenges and new, decisions that are made that define the future, so to speak. So we'll get to that in a moment, but tell me why IP, what's attracted you to that?
Good question. So going back to when I qualified this time 3.5 years ago, it was a question in my mind of corporate or commercial law. So I've always liked the academic side of law, enjoyed being at university and college, and the opportunity that was presented to me on qualifying with specialising in IP was something that drew me to the team and the area. Before then it wasn't really something that I'd directly learnt about. However, it's a really academic area of the law, and it's also very niche as well. There's not many people that specialise in it, and with all that being said, it's very topical as well. IP cases hit the headlines every day in the press, whereas other areas of the law not necessarily as much. So it's when presented with that opportunity a few years ago, it was something that I grabbed with both hands, really.
Of course, no, that makes complete sense, and obviously I know you better than most people who are probably listening to us today, so I'll probably share things which are things that I'm aware of, and I guess a key part is IP is so broad. Many people see it as just a copyright or a logo, so to speak. So Daniel, for people like myself who don't work in intellectual property or really understand how broad or narrow it is, can you explain to us intellectual property? What is it? How vast is it? And how important is it?
Sure. So intellectual property broadly covers creations of the mind, inventive steps and unique ways of doing things. So intellectual property rights are typically separated out into 4 areas. So it starts with trademarks. So trademarks protect distinctive signs, anything from a unique name, a logo, and it can even extend to things such as colours, smells, holograms, and basically anything that can be represented on the IPO's register and distinguishes goods of one business from another. That can be a trademark. There's also designs. So designs typically protect the shape of a product. They can also extend, in the case of registered designs, to colours, contours, patterns and that kind of thing. And then we've got patents and copyright. So patents protect unique inventions and ways of doing things. Copyright protects original artistic or literary works and extends to things such as musical performances, broadcasts, and song lyrics and that kind of thing. There's also quasi forms of IP, so confidential information, trade secrets. So you'll know, working in commercial litigation, but they typically attach to trade secrets associated with a business. Yep. So if an employee comes across customer lists or pricing lists or that kind of thing, that's typically what that attaches to. Some can be registered, such as trademarks, patents, designs. Some arise or subsist automatically, such as copyright and unregistered designs. and in most cases when it arises you get an exclusive right to use it, so if somebody else uses it and you don't let them, you can stop them.
Very good. All very serious then from what you said. It's not just something we hear on the news passing by, and we'll all have heard of recent examples. Maybe you can talk us through one that's more popular than, say, others.
Yeah. So people that I'm connected with on LinkedIn will know that I'm often talking about cases, developments in intellectual property, and particularly with trademarks. And as far as areas of law go, it's one of the most topical areas because it's developments in IP often hit the headlines because they concern multinational businesses. So recent examples are disputes with discount retailers, which we'll get to shortly, but also Marks and Spencer. Marks and Spencer is probably one of the most, on the one hand, reasonable brand owners, but on the other hand, if you don't do what they're asking, robust as well. So a recent example is somebody that used Percy the Pig in gelato ice cream. They were advertising it as Percy the Pig ice cream and using the small sweets in the products, which constitutes trademark infringement. Marks and Spencer's have got Percy the Pig registered as a trademark, and also the shape of the sweets themselves. And what Marks and Spencer's basically did is they wrote to the third party and basically said, it's our registered trademark, please stop using it, and by the way, here's a free bag of sweets, and that was the end of it. Brand owners stopped using it and got learnt a lesson. Marks and Spencer's came out at the other side and were applauded for not being too robust. On the other hand, there is an ongoing dispute with Marks and Spencer's and Swizzles about Percy the Pig. Swizzles essentially supply sweets into retail and distributors, including pigs that arguably look quite like Percy. Now that's necessitated a more robust response because Swizzles haven't simply stopped doing it. So it just shows that there's a couple of approaches, all of which quite often, especially when they involve large retailers, hit the press. Yeah,
that's one thing that whilst IP is everywhere around us, we see it in our day-to-day dealings regardless of what profession or background we come from. We only really pay attention when we hear of the bigger brands spending significant sums. On one side, their marketing team, like ours, gets a round of applause, and on the other, they're probably getting criticised because they thought this approach would work twice, and they're going to have to go more firmly to try and find a resolve, if, of course, they are correct in their assumption of their IP being passed off or whatever relative claim is being proposed.
Yeah.
So, given is it the headlines that attract people, or is it just the nature of the beast, so to speak?
I think it's a bit of both, really. Most businesses that I speak to, especially businesses that have been around for a few years, have found themselves in a position of either being a defendant or a potential claimant in IP proceedings in the past. Yeah. So they've either been hit with a letter of claim, or they've been forced to send one to somebody that's been using their own branding. Some businesses are quite brand heavy, so that might be a business that has a lot of sub-brands, branded merchandise that they sell, for example, or they might have a unique service which its component parts are protected by copyright, for example. But my advice to any client that I have or business that I speak to is always, at the start of any venture or new product line, it can be or new service offering, it's always, number one, what is the potential IP that can subsist in this product or service line? Number two, how can we best protect it? And then number three, how can we stop other people from using it?
No, that's a very helpful overview, because as you're aware, I'm in litigation, and we sadly see some clients coming to us at the very last hour. With IP, it's something where it's evidence-based. You have to be able to show exactly where things have gone wrong or where ideas have been, in essence, copied, amongst various other things. What would be your advice to clients who are really starting up and they don't want to incur them costs at this early juncture?
So the initial advice that I always give is identify the IP. So if you're starting a new business, the starting point there is the name. What is the name of your business going to be? Is it going to be a unique and distinctive name, such as a word that doesn't exist, or are you going to use a word that may describe the products or the services that you've got? Yeah. When you decide on a name, there's a few different steps that you can take, and this doesn't necessarily need legal assistance, but it's as basic as clearance searches to see if anybody else potentially uses something similar, and if they do, choosing something else. So once that identification has then taken place, you can then move on to step 2, which is, okay, how can I protect it? Yeah. But in addition to names, it then extends also to what's the output of our business. Is it going to be products that we can sell? Yeah. And in that case, is there a design that we can protect? Can we protect the packaging materials for the products, product names? There's a lot of questions that follow on from number 1 which is, what is the IP that we've got?
Yeah. And that's a service I believe you offer, or your team more appropriately offer, for both sides, so even larger companies who want to protect their IP, and smaller ones who really know what they want to do, they're really good at running the business, but don't want to, or don't know how to get up and running without that IP protection. And my understanding, and correct me if I'm mistaken, is a lot of people are put off when they hear of these large, as you rightfully pointed out, these large press publications of IP cases becoming substantial in terms of costs and time. But the reality is these preemptive steps in the grand scheme are just a proportion of costs that will help the business scale, if nothing else. Or are they correct in assuming these costs are quite excessive from the outset?
Yeah, so it's a good question, and questions about costs should never put businesses off considering what IP rights that they can have or that can subsist in their business. At its most basic, there are publicly available resources that are available to businesses, such as the UK Intellectual Property Office's website, the World Intellectual Property Organisation, and they give good advice as to the different forms of IP rights, being trademarks, designs, copyright and patents, how they subsist, how you can protect them, and ways that you can carry out due diligence. So, as you say, intellectual property services are often associated with a big bill at the end of the day. However, that doesn't necessarily need to be the case. If it's due diligence, that can be provided for fixed or bundled fees, as can prosecution. There are some elements, such as patent prosecution, for example, that can take a lot of time, and that warrants a lot more A, due diligence being carried out, but B, legwork to get the patent registered. But like many legal services these days, intellectual property services are often provided for fixed fees. So it's not really the most expensive service in the world anymore.
And given your experience, previous experience I know you spent time in the commercial litigation team prior to qualifying, so you get an understanding of the needs for clients and how, really, when the problem comes to light, how clients tend to respond. I think it's important with your commercial experience mixed with your commercial litigation experience. You're able to offer both the commercial advice as well as the legal advice. But just for anyone who's listening and isn't familiar with the process, the IP route or any claims that are presented under the intellectual property or protection of intellectual property, is that a completely different route or is it very similar?
Intellectual property has been, or rather there's been surveys carried out regarding intellectual property which show that it represents 90% of the value of businesses. So when businesses are sold, a lot of the times what's actually being sold is the goodwill and the reputation that attaches to a business's name and services that they provide under that name. So often during due diligence, investment rounds, questions that buyers will ask often concern intellectual property rights, in the sense of, does your trading infringe third-party IP rights? Is there a third party that's using your IP rights without permission? Because these are fundamental questions that anybody has when buying or selling a business, because if they don't, or there is a potential claim out there, then it can be quite costly to deal with and time-consuming.
Very good. No, that makes complete sense. I know some, on the other hand, would probably argue that copying or mimicking is the finest form of flattery. You as an IP lawyer, what are your thoughts on that?
Well, it is, but that's not to say that it doesn't constitute infringement.
Of course.
So there's a few examples of that in the local, or rather national press in recent times. For example, discount retailers such as Aldi and Lidl, they're notorious for selling mimic products which look like an established brand but aren't, but are essentially the same products. So there are studies that have been carried out that show that consumers, when they look at a product on the shelves, they look at the packaging materials and associate them with a certain brand. And in the case of discount retailers, when they offer a product which is basically the same from a representational point of view, consumers will buy that instead of buying the one that has the reputation that attaches to it. So as far as the Trademarks Act is concerned, that's taking advantage of that reputation, and in some circumstances it might even extend to passing off. Another example is a AI generated song that was produced recently. Essentially what the developer or the person that wrote the code did is they took Drake's songs, The Weeknd songs, and they basically merged them together to produce a track which sounded the same as them, but that was completely generated, or created rather, using generative AI. So arguably that's copyright infringement. The Copyright Designs and Patents Act 1988 doesn't really align with developments in the law, or developments in practice rather, but Spotify and Apple took that song down straight away.
Yeah, that's interesting. I was going to touch on AI because I know in the current climate it's at the forefront for everyone. There's one thing working more efficiently, and then there's another trying to profiteer purely from a shortcut. There's no other way for me to put it in simple terms. What are your thoughts, and do you feel Spotify took the right action? I know on social media there's been arguments both sides, and ultimately the law is the law, but you and I both know it's not as black and white as that.
It's a good question. I listened to the song and I actually quite liked it. So it's currently a grey area, and it's not just a grey area in the UK but also internationally. There's cases going through the US courts, for example, on similar issues. As far as copyright is concerned, and copyright attaches to literary works, musical performances, lyrics and so on, by taking Drake's songs and The Weeknd songs and making copies of them and transposing them into a new song, it arguably constitutes copyright infringement. It's not a straightforward avenue to bring that claim, but that's because the Copyright Designs and Patents Act it came into force in 1988, and a lot of it was even put in place before then. So when the legislature put that act on the statute book, they weren't considering generative AI in 2023. So it's as I say, it's a grey area. But if anybody's doing that, I'd typically advise them against it, because Apple and Spotify and even brand owners, publishing labels and so on will eventually come after them.
Of course, no, that makes complete sense. And whilst it's nice to see it so early on when AI is at the forefront and anyone and everyone can really access it to some degree, it's important to be careful yourself, even if you are testing it, so to speak, to get a feel of what you can and can't achieve. You don't want to be on the receiving end of a formal letter or any action by uploading this onto YouTube, Spotify or any other platform. Yeah,
that's it. And a lot of the uses of, say for example, ChatGPT or other forms of generative AI, is that you put a question into a search facility, it then comes back with a predetermined answer based on information that's already out there. But one of the other questions about it is ethics. We don't know whether that information is valid or accurate, and there may also be bias incorporated into those responses as well. So to leave to one side intellectual property considerations and potential copyright infringement, there's a whole host of ethical questions as well. And again, our data protection colleagues will know, but ChatGPT, for example, people's personal details have been leaked that have signed up to them in recent times. So there's a lot of legal and ethical questions with AI bots and generative AI, which I don't think are quite answered at this stage.
No, it's very early doors. And I think another key element is social media. 10, 15 years ago, not anyone and everyone could start up a business from home whilst also having a professional or a job, a full-time job as such. There's a lot of people who, I'm sure you've advised clients on this micro level as well as on the complete opposite end of the spectrum, where their product or their business is being what they perceive to be ripped off or ripping off in light of fads or current trends. Is that something you've seen a lot more? And if so, how should people be more vigilant and careful?
Yeah. So good question, and there's statistics that are published by national intellectual property offices such as the UK IPO and also the US Patent and Trademark Office. And what those statistics show is that during the pandemic there were a marked increase in trademark applications. So that reflects that a lot of society started working from home, they started their own ventures, and positively started to start thinking about protecting their brands and IP. In terms of using similar names, for example, the advice I typically give to clients is that if they've got a new name or a new logo, for example, to approach it from the perspective of there's probably already somebody out there that might have thought of something similar. It might not be in the same industry, and if that's the case, there might be a way to get it protected. But if it is, we need to think about, is this going to be registered? And the reason why I say that is that in the UK there's over 500,000 registered trademarks. As innovative as a business may be, there's always going to be some element of, is this potentially similar? So it's a case of carrying out the due diligence right at the start to make sure that whatever the name is or product name isn't already in use, and if it's not in use, get protection over it yourself.
Brilliant. And me, let's use an example, say as a brand owner, if I'm concerned there's a lot more businesses starting up from micro level, from home or from wherever, what can I do? I just don't have the resources to be able to be searching the IPO to see if there's someone setting up or registering trademark similar. Is there any advice or anything you and your team can do to help me on that front?
Yeah, so another good question. There's a few options. At its most basic, it's carrying out searches on search engines such as Google and so on to see if anybody else is using that name. You'll quite often see new results, and if there are, you can potentially write to them, ask them to stop. If somebody's registering a trademark that the Intellectual Property Office considers to be similar to your own registered trademark, they will tell you. However, there are cases where the IPO might not think it's similar and it slips through the net. So in terms of what we can do, we've got trademark watching software. So that essentially searches for trademarks that are potentially similar to your registered one. So if somebody attempts to register something that has that word in it, or a variation of it, or something similar, we will be told, and then we will tell our clients, and it's a relatively cost-effective service as well, and it's something that we charge either via our retainer options or for fixed fees, so it's really not as expensive as what clients might think it would be.
That's helpful to know, because as you say, many clients may not know how to access that information, and you make it sound very simple, but you've been doing this for some time now, and obviously it's your specialism. From the outset, I know a lot of individuals see IP as literally just copyrights, and having spoken to you on various matters, I know it's more than that. It's quite interesting, and there's a commercial element to it as well as the legal. Everyone has a different appetite to resolving disputes. Some clients, I'm sure, will want to come all guns blazing, to put it in that way. Others want to just eliminate what's going on and bring it to an end, and of course that you'll vary your approach accordingly. But I think it's important, regardless of whether you're on the receiving end or whether you're on the, delivering end, it's important to consider what your options are and consider carefully, because options such as rebranding or some form of settlement can become expensive and really bring a business to a halt, if not cripple it, if I'm not mistaken to say that.
Yeah, no, you're correct in what you say, and those are the options that are typically available. We quite often are instructed in distress circumstances. So a client has attempted to register a trademark and somebody says that it's similar to their own, or the client has been using it on an unregistered basis, which opens up a whole new can of worms, and somebody else has been using their own on an unregistered basis. Who used it first? Have we been coexisting? And the ways to resolve that case or claim, it can either be, number one, go all the way to a trial. That's often the most expensive and time-consuming option. Number two is try and reach settlement if you can. That might be via coexistence, which is essentially we won't step on your toes, you won't step on ours. But that comes with a caveat of, if you're in similar industries, a lot of the value in your trademark is lost. Or an alternative option, and typically one which I don't recommend, is to agree to provide undertakings from the offset. When faced with an IP dispute, it could be trademark infringement, copyright, or design infringement, or even passing off. Clients will often receive a long letter of claim with undertakings to pay damages, accounts for profits, surrender trademarks, and also paying legal fees. And whilst there are unjustified threats, protections for defendants, brand owners quite often overstep the mark with saying, don't use something similar to ours, even though there's no likelihood of confusion. So to use a practical example, we were recently instructed by a client to register a new trademark. We received a notice of intended opposition from a third party. They then opposed it without corresponding with us, and in response, the client was in a position where they've already started using this trademark, which is typically what we don't recommend, but
we live
clients
in the
are
real
clients.
World, yes.
But we're faced with a position of, do we withdraw the trademark application? Do we stop using it? But when we dug a little bit deeper into the allegations, the trademark that the other side had been relying on hadn't actually been used in the UK. So that made it prone to non-use proceedings and revocation. And we set this out to the other side, and they withdrew the opposition. So the takeaway point really is, don't panic if you get a letter like that. Step back, take stock, take legal advice, and in most circumstances you can either defend an opposition or an infringement claim or come to a resolution. You'll know with working in litigation that the vast majority of cases settle. In intellectual property claims, that percentage is increased because it's often quite a simple answer. Are you using our trademark? Yes. Okay, well, we'll stop. Are you using it? No. And then we'll carry on.
Thank you for that, Daniel. It's been very helpful. It's given me a clearer idea of what IP is, what you and your team are doing. I'm sure to anyone that's been listening, it's been beneficial. And if nothing else, it tells them to pick up the phone, give you guys a call, send you an email if they're concerned or worried about something, because there's so much more that can be done. As you've rightfully just pointed out, don't go into panic immediately. There's always a solution, and I guess we're here to offer that and find a way through with our experience together.
Absolutely, yeah. If anybody has any questions about IP or commercial law generally, most people will see that I'm quite active on LinkedIn. I'm also always on the end of a phone or email me. I'm always happy to speak to any business, large or small, about intellectual property rights and how they can protect them.
That was very helpful. Thank you for your time, Daniel. I know how busy you are, so it's much appreciated.
Thank you. Thanks, Sheroze.